ECI affidavit in the Supreme Court on hate speech. ECI affidavit reads that can't ban candidates till centre defines hate speech or hate mongering. Remember, the PIL had sought a ban on such candidates, and the ECI has now put the ball in the centre's court. And going straight across to my colleague Harish, who is joining us live on the broadcast for more on this. Harish, if you could please give us a little bit of more context and what the EC affidavit really says.
Yes, in fact, this was a PIL filed by BJP leader and Supreme Court advocate Ashwini Upadhyay seeking a ban on candidates who indulge in hate speech or hate mongering, and not only that, deregistration of political parties whose candidates have indulged in hate mongering or hate speech. So, in a very significant affidavit filed in the Supreme Court, the Election Commission has clearly put the ball in the centre's court. This ECI has filed an affidavit in the Supreme Court on hate speech. It has very clearly said that candidates till centre clearly defines hate speech or hate mongering, and also said it has absolutely no power to deregister any political party if candidates indulge in hate speech. In fact, this PIL has sought both either deregistration of party or ban the candidate from fighting the election. So the Election Commission has said that now we use only the Indian Penal Code or the Representation of People Act, which in fact does not give us clear powers to ban, in fact, a candidate from, prohibit him from contesting election or restrain him or deregister that particular party. So let me read out from the affidavit the relevant portion. It says, in the absence of any specific law governing hate speech and rumor mongering, Election Commission employs various provisions of IPC, like Section 153A, which talks about promoting enmity between communities, and the Representation of People's Act to ensure candidates of political parties or independents do not make statements to the effect of creating disharmony between various sections of community. And also said that time to time, advisories are also being issued appealing to parties to desist from these practices. It is also part of the election code of conduct, but nothing much has happened in absence of a clear definition as to what is hate speech or hate mongering. And this was the duty of the legislative, executive, or the parliament. So the Election Commission has also said there are enough Supreme Court judgments which have given ample powers to the centre to act against those indulging in speech and creating disharmony. And the affidavit also says that Law Commission in its 267th report suggested various amendments in criminal law to penalize the offence of incitement to hatred and causing fear, alarm, and provocation or violence in certain areas. So, in a way, the Election Commission has put the ball clearly in centre's court, saying that till the Parliament brings in a law defining what exactly is the hate speech or hate mongering, its hands are tied as far as de-recognizing a political party or candidates who indulge in hate speech or hate mongering. Back to the studio.
Right, Harish, many thanks for taking us through all those details.